opportunity now to make a comment or ask a question, and then our presenters will be able to respond. Thereafter, we close the meeting with a few closing remarks and agree on the way forward. So that's the program that we have for today, and we certainly look forward to an interactive session and hope that at the end of it all, you shall have taken something away that is useful to you, either as a person, as a community, or where you work, whichever the case may apply. So, ladies and gentlemen, allow me now to invite Robertson Kabucho, if he's online, to take us through, to make his remarks before we go to the presentation. So, Robertson, if you can hear me, please proceed.
Thank you, Henry. I can hear you, and I hope likewise I'm
Robertson?
audible.
Please unmute your mic or speak up.
I am unmuted.
Okay, proceed.
Thank you, Henry. I hope I'm audible now. I understand I am not muted now. Kindly confirm if I'm audible.
Yes, you are. Proceed.
Okay, thank you. And thank you, Henry, for this opportunity. And as introduced, my name is Robertson Kafusho. I would like to take this opportunity to acknowledge Cabinet Secretary, Madam Farida Karonei, and also the panelists, Sylvia Waiganjo. Greetings to everyone and all the participants and listeners who are present. I represent Hansard Foundation as the head of programs for Kenya and Ethiopia. And I'm here on behalf of our resident representative, Mr. Daniel Sebaling, who is away on travel and was not able to be joining us this afternoon. So I'd like to take this opportunity to commend the Kenya Alliance of Resident Associations for the wonderful platform you've given participants to access more information on today's subject. The Kenya Alliance of Resident Associations has been a key partner of the Hansard Foundation for many years, and through this platform of the monthly talk series, the platform especially provides citizens an opportunity to engage with a variety of stakeholders, whether in government, academia, civil society, on different issues, pertinent issues, as Henry mentioned, that are of interest to them. And we are glad to have walked this journey with Kara. The Hansard Foundation is a German political foundation. Our work in Kenya is in 4 main areas of law and good governance, sustainable economic development, youth and gender, and climate change. Our office in Nairobi covers work in Kenya and in Ethiopia. And we work with local partners in government and in non-state actors, whom we support to implement different activities and different projects in all those 4 thematic areas, such as the Kenya Alliance of Resident Associations, who we work with in organizing this kind of dialogues. So without taking so much time, we are glad to have this opportunity this afternoon and this being a key topic, especially for the public and the industry players, to gain the relevant information and hoping that it will also trickle down to the rest of the citizens. I would like to therefore wish everyone a very productive engagement this afternoon and happy discussions. Thank you very much. Back to you, Henry.
Thank you very much, Robertson, for those remarks. And of course, always a pleasure to have you as a partners initiative. So without wasting more time, let me proceed straight to our first presentation. And like I mentioned, Sylvia Waiganjo, who is managing partner from Gerivia Advocates, is going to share with us her thoughts on the subject. And thereafter, we are going to listen from the Cabinet Secretary. So Sylvia Waiganjo, if you can hear me, please proceed and make your presentation.
Thank you very much, Henry. And thank you for having me in this session. I'm very honored to share the platform with the CS, and I'm hoping for a fruitful engagement. So given my allocation of 10 minutes, I'll go straight to the specific highlights of the Act. And perhaps the first thing I'd want to say is that the Sectional Properties Act 2020 is aligned to the Constitution and to the Land Act and to the Land Registration Act. And when I was thinking of a simple example of such alignment to give, one of them would be like the definitions or the wordings under the new Act. So while the 1987 Act referred to local authorities and the repealed Registered Land Act, the new Act talks of county governments when it comes to issuance of approvals, and it also refers to the Land Registration Act. So that's just one of the things that shows it's been aligned to the new land laws and to the Constitution, sorry. One other thing I thought I would highlight about the Sectional Properties Act is perhaps what I think is the motivation or the rationale behind this act. A few things come to mind, including there were no standard plans registered under the RDA. And now under the act, there'll be a sectional plan. There are specific requirements for these sectional plans. And so there'll be uniformity in terms of the plans that are registered, given that they are supposed to be prepared by licensed surveyors. So there's issues surrounding the management company, including issues of where the units are developed exceed 50 and the management company has to be incorporated. That would have had to be a public company as opposed to a private company. Under the Sectional Properties Act, the corporation will be established under that act, and the Companies Act won't apply to it. Another rationale or motivation behind it would be the persistent failure by developers to transfer shares in the management company to the owners, even failure to transfer the reversionary interest. And some of these things would only be known to owners of units, perhaps when you approach your bank for a facility and they request that you provide your share certificate and you do not have it. There's also the issue of rates and rent. How it works now is that the funds are pulled from the owners, either they're charged as a portion of the service charge, then the management company has to see that the rates and rents are paid. Under the new act, there's apportionment of rates and rent for each unit. And the other thing I would say that is also one of the things that the act was trying to address is the reversionary interest being vested with the owner, so that it affords the owner the first right to renew once the lease expires. So generally, the lease applies in respect to land held on a freehold title or on a leasehold title, where the unexpired term is not less than 21 years. And there has to be an intention to confer ownership. So the simplest way to explain this act is to, you have to envision shared amenities. Shared amenities have to come to mind. So if you have a unit and you have to share the pathways, the walkways, the parkings, the swimming pool and all those things, these are the units that are targeted by this act. So it deals with the division of buildings into units, and those units are owned by individuals, and the owners of those units own the common property as tenants in common. So I have already given generally the definition of a sectional unit. It is a space in a building. It is described in a sectional plan, and it should include the proportionate share of the common property. Examples of such units are apartments, flats, maisonettes, townhouses, villas, and even offices. So this unit is described in a sectional plan by making reference to either the floor or the walls or the ceilings of the building. So I want to summarize the highlights into 4 broad topics. Is the registration of the sectional plan, the management of the units, conversion, and if I have time, I'll touch on sale and renting of the units. So the preparation and registration of the sectional plan. Before I get there, for this, for the sectional units to be registered, you need to register a sectional plan. So the sectional plan is simply a georeferenced plan of the units. It is prepared by a licensed surveyor, approved by the Director of Survey, and then registered by the Ministry of Lands. So there are a few things that a surveyor would need before they prepare the sectional plan. One of them is your approved building plan, the building plan approved by the county government. And you would also need to show the surveyor proof of ownership, that is either the title to the title deed or the certificate of lease for the parcel. As the surveyor is preparing the sectional plan, there are certain requirements that this plan has to meet. They're very detailed. A few of them that I'll mention is that it has to be georeferenced. It has to contain the particulars that identify that title, like the title to the parcel. So it has to be a sectional plan relating to land reference number XYZ. There should be a drawing of the units, and they should be marked clearly. So if they're numbered 1, 2, 3, unit A, B, C, all this should be illustrated in the drawings. They should be signed by the Director of Survey. They should also be signed by the proprietor of the parcel. The parcel here is the land where the building which contains the units is. The plan, okay, a part of the requirements of the sectional plan are that it should also indicate the user of the unit, whether it's a residential unit, a commercial unit, yes. So aside from those requirements, there are also some documents which are supposed to accompany that sectional plan as you're submitting it to the Ministry of Lands for registration. Among them is, of course, the application to register that plan. You need the original certificate of title or lease for the property, for the parcel of land. And you also need an application to register the corporation, a list of persons who are owners. For that list, it can be amended over time if the new owners listed. You'll also need an endorsement from the surveyor. He just needs to state that the structure on the plan is within the external boundaries of the parcel of land. And you'll also need an endorsement from the county government, okay, endorsement or certificate, just stating that you proposed the structure that they had approved, The structure on the plan had been approved by the county government. Once you have submitted your sectional plan to the Ministry of Lands, a few things are going to happen, which I like to call the effects of registration of the sectional plan. So the first thing that will happen is that they will close the register of the parcel. The parcel here is the land that has been described in the plan. They will open separate registers for each unit described in the plan. So if the plan describes 20 units, they'll open 20 registers for each unit. Then in respect of each unit, they'll issue a certificate of title if the property is freehold, and they'll issue a certificate of lease if the property is leasehold. Then also the corporation where the owners of the units are members will be established. Great, so after registration of the sectional plan, the other thing that has been coming up a lot is the question relating to common property. What happens to the common property? So the common property is to be held by the owners as tenants in common in shares proportionate to your unit. So for the example of the 20 units, so it means your share, if the building has 20 units, your share of the common property will be 1/20. And when opening the register, for each unit, your 1/20th share in the common property will be indicated. And equally, this share in the common property will be indicated on the title for the unit. So the thing about this that comes out clearly is that the common property or the common areas, they'll no longer be owned by the corporation. And by common properties or common area, this is any area that is outside the walls of your unit. So I'll want to touch a little on management of these sectional units. So I've already indicated that when you register the sectional plan, a corporation will be constituted. So what you'll note about the Act is that once the corporation is established, it will be established under a specific name. The name will be the owner's, sectional plan number. So the thing that will be changing is the sectional plan number, which means that now these corporations won't have names that people used to pick out, like South Lake Association, Management Company, or something of the sort. All the names will all read the owner's sectional plan. What will change is actually the plan number, depending on when the sectional plan in relation to those units is registered. And once the corporation is established, the registrar will issue a certificate of registration. So this corporation will consist of those people who own units. It will have perpetual succession, a common seal, and it will be regulated under the Sectional Properties Act and the bylaws in the regulations, and it will not, it's not subject to the provisions of the Companies Act. So if you read the Act, the management company has a number of duties. It also has a number of powers. So some of the duties are keeping the common property in a good state of repair, managing and administering the common property, maintaining a fund for administrative expenses, and effecting insurance, paying premiums. Those are some of the duties. So some of the powers that the corporation has is that they can use technology to execute their duties. They can constitute an internal dispute resolution committee. And when it comes to issues of perhaps renting of the units, you'll find that the corporation has power to issue a notice to a tenant to vacate a premises. without consulting the owner of the unit. When it comes to conversion, there's a requirement under Section 13 of the Act that all leases that were registered before, that were intended to confer ownership and that were registered before the commencement of the 2020 Act, they need to be reviewed to conform to Section 54, 5 of the Land Registration Act. So how I can summarize this conversion is by saying it applies to units which have been transferred to respective owners by way of long-term lease, and the reversionary interest has been transferred to the management company, or the leases have been transferred to the owners, but the reversionary interest is yet to be transferred. Or maybe some leases have been transferred to the owners, some have not. And there are also leases which they're long-term leases, but the reversionary interest is not provided for. So this conversion aspect affects all those people. So in a conversion process, in brief, you go back to the sectional plan. So you prepare the plan, which has to be prepared by a licensed surveyor, signed by the director of survey, and it should be endorsed by the county government. You submit the plan to the Ministry of Lands for registration. Again, remember when you're submitting the sectional plan, it has to be accompanied by the application for registration of the corporation, the endorsements, all those things have to be in place. Then once the registration of the plan is done, again, we go back to the closure of the register for the parcel, opening new registers for each unit, and issuance of new titles for each unit. The only thing that it would be different in the conversion process is that now after the registration of the plan and issuance of the new titles, there are a few things that have to be attended to relating to the management company, which include now transfer of assets, the assets that are held by the management company to the corporation, and the winding up of the management company. So things to note, two things to note about conversion is that it can be initiated by the developer, by the management company, or by the owner of a unit. Another thing to note is that during a conversion process, for those who already have leases that were transferred to them, you'll not be required to pay stamp duty again if you had paid stamp duty. The documents, additional documents that will accompany the sectional plan in an application for conversion include the sublease for your unit or the long-term lease for your unit. It has to be part of the documents that you submit or you surrender to the lands office. So as I've said, after conversion and after you're issued with the new title to your property, what now follows new title to your unit, what will follow now is the winding up of the management company. So the regulations are still in draft, so they're yet to be passed, but the timeline that has been suggested under the regulations is 1 year. From the date of registration of the corporation, the management company should have been wound up and the assets and liabilities should have been succeeded by the corporation. I'd also like to highlight the issue of sale of these sectional units. There are now mandatory documents that a purchaser needs to be issued with at the time you're selling a sectional unit. So they include the purchase agreement, the bylaws or the proposed bylaws. So under the regulations, there are there are bylaws there that you can adopt, or you can elect to come up with your own or amend them, provided at the time you are registering the sectional plan, you submit the bylaws. You'd also need to provide the purchaser with the management agreement or the proposed one, if any. You provide the recreational agreement or the one that you propose to use. Again, this is if any. So it means this too, it depends really on the developer, and they're not, you might not have a management agreement. The bylaws would still cover a few of these issues. So you'd also need to provide a lease or the title to the parcel, where that unit is to be located. And if at the time you're selling the unit, you've already gone through the process of registering the sectional plan and you have obtained the individual titles for the units, you need to provide that to the proposed purchaser. If there's any charge or proposed charge that will affect the title, you also need to notify the purchaser, and you also need to give them the sectional plan or the proposed plan. Those who are selling sectional units and are financed developers, there are some additional things that you have to give the purchaser. So this means this affects the developers who obtained financing to put up the building or the units. So you need to disclose to the purchaser the principal amount of the charge, the maximum installments that may be payable under the charge, the term of the charge, the rate of interest, any prepayment privileges that might be there, and the amortization period. Just something I want to mention on renting of sectional units. So if you're the owner of a unit and you propose to rent it to a third party, you have to issue the corporation with a notice of your intention to rent the unit, and you also have to provide the corporation with details of the proposed tenant. This part really affects those unit owners who they own the unit, they do not reside there, and they simply collect rent. So you'll need to give a notice to the corporation to this effect. You'll also need to undertake to be liable for any damages to the unit when the tenant is there. And you also need to give notice to the corporation when the tenant vacates the unit. And one of the powers I was talking about now for the corporation is that if the tenant now contravenes any bylaws, the corporation can give notice to the tenant to vacate. And this is with or without the consent of the unit owner. Aside from that, the only other thing I'd like to say is that though the Act commenced on 28th December, the regulations are still not yet in place, and some of the provisions are therefore not fully operational. And I'm sure the CS will make comments on that and what the ministry is doing to ensure that the Act can be fully operational. With regard to conversion, again, for those who have leases and the leases are registered in your name, the way the Act is drafted now, there's a timeline of 2 years within which you're supposed to undertake the conversion. And of course, there are fines stipulated and consequences specified if that does not happen. Again, it's a bit unclear whether this whether we'll be able to meet the timeline, because ideally 2 years from 28th of December means the deadline for conversion would be 28th December 2022. So with the issues relating to the regulations not yet being in place, it is a timeline that is concerning many, but it's one of those things that we need to wait and see how the situation will evolve. So Henry.
Yes. You're done?
I had received some advanced questions over here.
I think you'll deal with that. Yeah. So in that case, then I have to believe that you're done with the presentation.
Yes.
Okay. Thank you very much for that, Sylvia. And I think you've given us just an insight of what are some of the key provisions of the Act in relation to issues of registration, management, conversion, sale and renting, which are some of the questions that we've been receiving from various property owners. And I'm sure as we go along, whatever is not clear will still be made clear. And we should be able to be at a better place to understand what is expected of each of us in terms of even the implementation of the Act. So with that kind of background and that kind of information, we will now want to hear from the ministry, and the Cabinet Secretary is here with us just to also share with us her thoughts and of course the plans at the ministry in terms of making sure that the objectives of this Act are actually achieved. We've heard that there's already a process on putting in place the regulations. So we also want to hear where that is and how we are going to interact with that particular, with the regulations moving forward. So allow me, ladies and gentlemen, to invite Madam CS Farida Karone, who is in charge of lands and physical planning, to speak to us on the subject of discussion today. So Waziri, if you can hear me, please take the floor.
Yes, Henry, I can hear you. Can you hear me?
Yes, we can hear you.
All right. Good afternoon, everyone.
Afternoon, Karibu.
I think Sylvia has done a very good job in giving context and just basically explaining what this law is about. But just to sum up what she said, by saying that this law is one law that is very good for property and homeowners, and it was intended to protect their rights. And its enactment was motivated by the fact that the Sectional Properties Act of 1987, which was repealed by this current act, was not fully implemented. And therefore, a lot of the sectional units in our urban centers are registered through long-term leases. So I will not belabor what she has said because I think she's really basically explained. It's a very straightforward and very simple law. It's aligned, as Sylvia said, to the Constitution, to the Land Act, and to the Land Registration Act. So the way I intend to consume my 10 or so minutes is basically cluster some of the issues that stakeholders have been having into about 6 areas and try to respond to them. Then we can respond to the specific questions. We received about 32 questions, most of which have been answered by Sylvia's presentation, but will also be answered as I speak. So I'll just focus on the 6 areas that many homeowners and many stakeholders in the sector have concerns about. The first, of course, is the fact that this law gave us a 2-year period to migrate fully to the ambit of the Sectional Properties Act of 2020. Of those 2 years, we've already consumed about 8 months, which means we have basically 1 year, 4 months to comply. However, it wasn't possible to start the full implementation of the law because the regulations were still under development. It took a lot of engagements with stakeholders, but I think I'm now happy to report that the regulations are happy for presentation to Parliament. As you know, Parliament, the Committee on Delegated Legislation has to scrutinize these regulations before they are published and before they become law. So that is, we are at the home stretch now. We've gone through public participation. We've collected the document. And we have a date for the 30th of August with the Committee on Delegated Legislation for them to scrutinize the regulations before we publish. Usually they have what they call a pre-publication scrutiny, where the Committee on Delegated Legislation on behalf of Parliament will scrutinize the regulations so that you publish them and then you can start to implement the law. So we hope that within a month after the exposure, which is on the 30th of this month, they should have given us the go-ahead. And our estimation is that by the end of September, the regulations will be ready for implementation of the law. That means we will have about 1 year and 3 months to fully implement this act. So we'll work with stakeholders to see how quickly we can implement this law. But in the event that we are not able to cover the full conversion by that time, by the end of 1 year, 3 months, because the end date is December of 2022. So if we don't manage to cover that, we can then work with stakeholders and with Parliament and see whether we can seek an extension of time. But we want to work very, very closely with our stakeholders so that we do the conversion within the stipulated time, which is by December of 2022. We have set up a special unit in our ministry, in the surveys department, to help our customers with this conversion process. And we'll also work, we have a task force with licensed surveyors working to help us understand how we can work together to quickly move the process forward. So in terms of regulations, I think a lot of the questions we have in our 32 set of questions is asking when are you publishing the regulations? So that the answer is by the end of the month, we'll have met with Parliament. They will have gone through our regulations. We think we have done a good job with the stakeholders, and therefore we don't foresee a challenge with the Parliament passing the regulations. And we do hope that by the end of September, the regulations will be ready for full implementation of the law. The other key concern I see our stakeholders have is people are asking whether conversion is mandatory. The answer, yes, it is mandatory. And why is it mandatory? Because this law has been written to conform not just with the Constitution, but also with the Land Registration Act, Section 54(5), which determines how you register these sectional units. So conversion is mandatory. And as you heard Sylvia saying, that if you do not comply, there are penalties for non-compliance. But we don't see a big challenge because we are going to work with our stakeholders, making the resources of government available and also working with the private sector to make sure that the conversion process is not too painful for homeowners and for stakeholders in the sector. The other key concern of stakeholders is really there are two issues that have worried stakeholders concerning the implementation of this act. And this is, what do you do with the phased developments? And what do you do with mixed use developments? You know, the law says that you close the mother title once you register the individual units. As you register the sectional plan, then you begin to issue individual units for the individual titles for the individual units. But in the case of phased developments, where the developer is putting up units in phases, what do you do? That is one of the concerns that came up when we were doing a public participation for the regulations. And we have proposed to deal with this by amending the Sectional Properties Act itself. So one of the recommendations we have from the task force that did the regulations is to do some amendments to the law to accommodate phased developments and also mixed use developments where you have homes and you have offices, for example, or a shopping mall together with homes. So those kinds of developments are not properly accounted for in the Sectional Properties Act of 2020. And we want to work with Parliament to amend the law to accommodate these two developments. So I think our stakeholders should not be too worried about what should happen because we already have taken on board the concerns that were presented to us during the debate on the regulations or the public participation on the regulations. And we have proposed to deal with that by really working with Parliament to amend the law. One of the other concerns we have, or one of the issues, or not really issues, that comments came in from our stakeholders is why this law? Why is the government so keen to implement the Sectional Properties Act of 2020? So apart from just complying with the law and with the Constitution, as I said, this is a law that is very beneficial to homeowners. And as you know, the government would like to encourage home ownership. How does it encourage this? Under the long-term leases. I think you had Sylvia saying that reversionary interest would be left either with the management company or with the developer. So as a homeowner, you really didn't have absolute ownership or absolute rights to your unit. But under this law, one of the benefits you will enjoy is that you have the reversionary interest, meaning that at the expiry of the lease, you obviously have the first right to renew the lease in your favor. Then, of course, you have a title in your name, which means you can exercise the freedom of using your asset in whichever way you want to use without reference to the developer or any other third party. It also allows you to own jointly the common areas. I think these are things that Sylvia has already spoken about. You have a proportionate share of the common area. In the previous framework, when we were registering long-term leases using RDA, some developers would be a bit cheeky and would use the common areas for uses that are not convenient for homeowners. So that's one thing that has been cured by this law. So you have a proportionate share, and you had Sylvia said that your proportionate share will be listed in your title. And then, of course, if you want to, say, mortgage your property or you want to pay rental rates, it is apportioned proportionately to your unit. So you don't need to come together with other homeowners in order to meet your obligations or exercise the freedom of your asset. In terms of what this means to the economy or to the homeowners, really, when you have the freedom to use your asset whichever way you want, I don't need to enumerate the benefits of having a title in your name. One of the biggest programs in our ministry is the National Titling Program. And it's a big program because it's important to guarantee security of tenure and to guarantee the asset that you have, that is really yours and you can exercise it in the manner in which you prefer to exercise. I think another key concern that has come through is because of the amount of time we have spent developing the regulations, which is really about 6-7 months now. What will happen when the expiry comes at the end of 2024? I think somebody was saying, will there be an extension of time? And I think I've responded by saying we will work with the Parliament, we will work with our stakeholders when that time comes, because let us first work as best as we can to see that we are fully implementing the law. But if it becomes difficult, then at that point in time, we can say, okay, it's not been easy to comply, to finish the conversion process. So we can then see what to do at that point in time. I think the other key concern is this georeferencing. Georeferencing is really a lot of science to say that you need to place coordinates in your apartment or in your unit or in your villa or your townhouse. So georeferencing is a prerequisite for registration of the sectional unit. And georeferencing is really just generating geospatial data or coordinates for your apartment. It would really tell where is your unit, which location, if it is in this apartment block, which floor, what is the area, those kinds of things. And these, as Sylvia already indicated, are done by a licensed surveyor, approved by Survey of Kenya, by the Director of Surveys, and then registered by the ministry. So the georeferencing starts when you start the process of conversion. I think the question that had come through is, when will you start georeferencing? And that is really the responsibility of the homeowner, because it is you, the homeowner, who will start the conversion process. But as I said, we'll support the process by making the resources of government available as and when they are required by our stakeholders. So georeferencing will start as soon as the regulations are in force and we start the full process of conversion. And as I have said, we expect that by the end of September, the full the regulations will be in force, and therefore the full implementation of the law will be in force. So georeferencing is really just creating geospatial data, which will create the sectional plan, which you need to register your unit. And you need to register the sectional plan in order for the ministry to close the mother title and give you an individual unit. So that's an important part of the implementation of this law. And I think for homeowners currently, one of the challenges we face at the moment is because the current National Land Information Management System has been built to comply with existing law or current law. So a lot of the sectional units in Nairobi are not on the National Land Information Management System because they do not comply with the Sectional Properties Act. However, in cases where property owners want to charge or want to exercise the benefit of their investment, we are working with them. And as I've said, we have created a section in Survey of Kenya to help our homeowners or property owners in Nairobi to migrate. So we are helping them to create the sectional plan, which will then subsequently allow them to do the conversion process. So that is one area that as a residents association and as players in the sector, you will have to work very closely with the ministry, because we really need the homeowners to convert so that they enjoy the benefit of using technology or using the National Land Information Management System. And that takes me to one, I think one of the questions from a lawyer, and I think his name is Dennis. Dennis was asking, why does RDSASA not work? It is not really true to say that RDSASA does not work. Because of our history and because of the challenges of land records and management of land records in Nairobi, a lot of the land records we have, and only Nairobi Registry, by the way, is live with about 87,000 documents or title documents. A lot of these title documents are not clean. And by clean, what do I mean by they are not clean? We set certain criteria for migration to the digital platform. One of them is that we said our data has to meet 3 components. It has to meet the integrity test, which means when we interrogate the data sets, we have to be satisfied as government that that data has integrity and the title was not acquired by fraud or through fraud. The other issue that we are assessing very, very closely is completeness of data. I think as stakeholders in our sector, you know that a lot of the data in our ministry is either incomplete, lost, stolen, corrupted. So completeness of data became a key criteria for assessing whether we should upload that data set or not. And the other one, of course, is accuracy. Is our record or our data accurate? If it says the land belonged to Farida, for instance, is it Farida's the land across all the departments of the ministry or not? So for this reason, out of the 87,000 title documents in the Nairobi Registry, as you know, Nairobi has 2 registries, Central Registry and Nairobi Registry. Central Registry, we are still running it manual because we wanted the Nairobi Registry, which is a smaller registry, to stabilize. And there we have about 87,000 title documents. However, out of these 87,000, only about 25,000 or so are 100% clean, which means it has integrity, it is complete, and it is accurate. The rest, we are still in the process of either filling the gaps in data. Some files are missing. What are we doing? We are calling landowners, bring your documents for reconstruction. Others, the data in the system is not accurate. Others, it is just, you can already tell that it was acquired by fraud. And others are title documents which have been registered over public land. And we have several of those encroachments on road reserves. We have encroachments on green spaces such as Karura Forest, Uhuru Park, Ngong Forest, encroachments on airports. All these are title documents which are registered in our registry. However, when you place them spatially on the ground, they're on public land. So when you come on the platform, these land parcels will not be available. So it is because of the challenges of data that professionals such as Dennis are struggling to use our platform, because the platform has been built and was built first to prevent fraud and secondly to secure our records. So the first thing we need to do is to ensure that when we put records there, it is records we can say with certainty that these are clean records. So Dennis, I'm afraid maybe you can reach me later or reach our customer care and we can sort your specific problem. But really the main reason why people are facing challenges interacting with the platform is because of the quality of our data. But as far as the sectional properties are concerned, which is the subject of today's conversation, only about 10,000 of them are on the platform. And these are the ones that had been registered using the Sectional Properties Act of 1987. The rest, and you know there are about maybe 100,000 or so units in Nairobi, the rest will await the conversion process because most of them have been registered as long-term leases. So in terms of implementation of this law, I don't want to speak too much. I think I'll leave the rest to plenary. We are very keen to make sure that we start implementation as soon as the regulations are ready. We want to work with all the stakeholders to ensure this is happening. In terms of whether we will ask for time, we want to see how much we can do within the time that is allowed by the law. If we feel that it is not possible, then we can ask for extension of time through amendment. But by and large, we see this as a law that we really need to implement because it's good for homeowners and property owners. And we also do not want this law to suffer the same fate as the 1987 Act, which was really barely implemented. It only registered about 10,000, about 11,000 units. Yet there are so many sectional units in Nairobi. So colleagues, in a nutshell, that is really it. We are just about to start full implementation of the law. We want to work with you. We are open to conversations and we are open to engaging with you to see how best we can implement this law. If there are issues that need me to respond, I will respond during plenary, but I think I've covered the areas where I felt that people had a lot of issues regarding the implementation of this, this particular act. Henry, I think I can stop there, then I will be open to take questions in plenary. I think we have a colleague, Tom Abuta from the ministry, who was in the task force for the regulations. I will also be happy to let him through to help us with some of the questions during plenary. Thank you, Henry. Thank you, everybody.
Thank you very much, Waziri, for those very, very useful information. I think you've dealt very well with some of the questions that have been asked earlier. And I'm sure that if there are going to be any questions, there are going to be new ones, different from what Waziri has dealt with. But she's given us insight on a number of areas, including the timelines, when we should be able to have the regulations in place and start implementation, the benefits of having this law in place, issues about disaster, and many other that he has talked about. So we are going to engage the speakers on the topic of discussion. So if you have any question that you want to ask either Waziri or Madam Sylvia, please raise your hand and we'll be able to pick it from there. We'll give you a chance to be able to ask a question. But I also note that there's already a lot of interaction going on the chat box. I've seen a number of questions being raised and some responses have already been made through the chat box. And I think that is very, very encouraging. But if you have any clarification or any question that you want any of the presenters to respond to, you can be able to raise your hand using the icon that is there, and then we'll pick it up and give you an opportunity to ask your question. I can see there's somebody called Charles Gatecha who has his hand raised. Gatecha, do you have a question or? Unmute if you have a question, Bwana Gatecha. Oh, it seems to be having a problem. As we wait for Gatecha, anybody else has a question, raise the hand. There's a question here that goes to the CS. Maybe you can be able to look at it. And it's anonymous. How shall we progress matters for registration under sectional property under the Nairobi Registry? That is Nairobi Block Group, which is in the process of going under RDSASA. As it has stalled for the last 2 or 3 months, nothing has moved. This will affect the speed of a financial purchaser. Perhaps you can revert to physical booking as you sort this issue out. No help is forthcoming from a team at Lance. Kindly intervene. I think that's a question for one of the participants. And how many applications for verification of property details have been successful on the RDSASA platform? I think Waziri spoke extensively regarding RDSASA, but perhaps she can be able to make clarification on some of those questions that have been raised from the participants. And of course, I want to take it that you have been able to really understand very well what the Act talks about. because I can see very few, we're not having many hands being raised to ask questions. But maybe in the meantime, Waziri, there's a question that I've asked is in the chat box. Perhaps you can just give a quick response to that as we move forward.
No problem. I can respond. I think the person, I don't know why they are anonymous, but anyway, they wanted to understand why the process of enlisting or verification of properties on RDSSA is slow and how many we've had since the launch about 3 months ago. So that, and she's also asking whether we can allow physical launchments of documents. Now, there are two registries in Nairobi, colleagues. There's the Nairobi Registry, which is live with RDSSA, and the Central Registry, which is still 100% manual. The reason why we left the Central Registry to be 100% manual is because of the teething problems or challenges we are facing in the Nairobi Registry, and we did not want to compound the problem. So Central Registry is still 100% manual, and transactions are going on in that registry manually. As for Nairobi Registry, we took the decision as government that we were not going to permit manual transactions. And this is the reason why, colleagues, the National Land Information Management System is an integrated platform. It integrates data sets from Survey of Kenya, which is the survey plan or the registry index map. It integrates data from physical planning or the PDP, the planning document, data from valuation, data from registration, and data from land administration, which is basically just the correspondences around land registration. Why did we do this? Because of the quality of our data. I think anybody who lives or works in Kenya or is even visiting Kenya understands the challenges of fraud in our sector. There are title documents where you have 5 titles to 1 parcel of land, or you have a title deed and you don't have land. And that is why it became necessary to integrate so that we say survey plan or the registry index map is the primary document. Why is this a primary document? Because for you to have a title, you must have land. So that integration became necessary for that reason. And that way we have been able to take out title deeds, which are in the registry as registered title documents, but they don't have land on the ground because they don't have a survey plan. So that integration is important. The other reason why integration is important is looking at the planning documents and the valuation documents. One of the things we realized, or which came into the fore when we started this process of integrating these data sets, is the fact that government has bought about 700 or so parcels of land in Nairobi, but only 50 have been vested in government. It means the other 650 are in the hands of private individuals, even though they've been bought by government and therefore are government assets. So this process of counter-checking this data set is a very laborious process, it's very tedious, but we must never forget the reason why it became necessary to develop the National Land Information Management System, because we wanted to manage our data in a transparent manner, in an accountable manner, and to cut out fraudsters and brokers. So yes, it is slow, it is painful, but what is the alternative? Should we continue further deterioration of our records, further theft, further misplacement, or should we say, let's draw the red line and say, here going forward, we are going to do things properly. Backwards, back to 1963, we can forgive you for the crimes you committed. Nonetheless, we must be sure who owns land. If we are going to put on record 87,000 title deeds, we must be sure who is a legitimate owner and that nobody has been dispossessed or defrauded because of the opaqueness of the management of our records. So the process has been very slow. We've had about 800 applications. I think somebody was asking how many applications for verification have come on the platform. We've had about 800 of them on a service we are calling an on-demand service. About 350 or so of them are from other parts of the country, which means they are not eligible to even be verified on the platform because only Nairobi Registry is live. The remainder, about 225 or so, are okay, which means they are clean and they can continue to proceed with the transactions. Others have different issues, which are being sorted by the ministry. In terms of actual transactions that have happened, I think there are about 100 or so that are now ongoing on the platform itself, on the digital platform. And that is because from the 4th of June, we disallowed manual transactions. So there are no manual transactions in the Nairobi Registry, except with very, very minute exemptions where there are issues and we have to allow a manual check. Otherwise, we are now saying, let us suffer the pain, let us work the journey together, but eventually it will stabilize. That is really the case with all technology platforms. The Apple iPhone, we are now on iPhone number 12. The first iPhone came out in 2007, but to this date, they are still improving. So even though we are struggling, and I appreciate and feel the pain of lawyers, especially in conveyancing lawyers because of the slow pace of transactions, this is really a pain we have to suffer because we are telling ourselves, we've had enough madness in our sector. Let us stop and let us do things properly. It's going to take time because we have corrupted our data over time. And it's a very, very tedious process trying to put the data sets together and try to make sense of the confusion we have created. So unfortunately, we just have to suffer the pain until the system stabilizes. As I told the private sector players when they came to see me last week, we expect to have fully stabilized in another 3 months or so. But we are working very hard to make sure that the system stabilizes. Thank you.
Thank you very much, Aziri, for those responses. I'm sure that as far as the question is satisfied. As we move along, Sylvia, the questions that were sent to you in advance, I know some of them you've been able to cover during their presentation, but I think there are about 2 or 3 that you did not touch on. So Sylvia, if you can hear me, maybe you can just be able to look at the question that were sent to you and then give your response. And just quickly, that one of it was that how is the property succession affecting children out of wedlock? I think this is something different. But what are the main implications of this act of landowners who owned land before this act came into place? And what is the implication of the Sectional Act on commercial rental spaces? And I think there's another one which talks about what does it entail to get a sectional property title of a flat in the Kilimani or Westlands area of Nairobi from a previously registered lease. So those are some of the questions, Sylvia, that were asked directed to you. So perhaps you can just cover them as we respond to each of them. Sylvia, please.
Okay, so when it comes to the implications of the Act on landowners, I was a bit unclear on this question because unless the landowners, here the reference was to landowners who are developers and have put up buildings with sectional units, either with the intention to sell them or have already sold them. Because when you said landowners generally, then the act wouldn't affect someone who owns land under a freehold title and they've put up their bungalow and they live there. Or perhaps you have land and you use it for farming. So in fact, the answer I've given here, I've put a question mark because I didn't really understand the question. So again, for number 2, what is the implication of the Sectional Act on commercial rental spaces? So this again goes back to, there has to be an intention to confer ownership. So if you just rent office space in a building and you do not own that unit, you are just simply renting it, then the act will not affect you. It will only affect now the owner of the building and the intention, where there's an intention to confer ownership of any of those units. The other question was for what does it entail to get a sectional property title of a flat in Kilimani? So I understood this to mean what are the added advantages of the title that will be issued under the Act as opposed to the long-term lease. And as the CS has said, some of the advantages include that you'll get an individual title to the flat. Your share of the common property will be indicated on that title. For the reversionary interest, you'll have the first right to renew. Your rent and your rates have been will be specifically apportioned to that flat. The only other question I'm seeing here that has not been addressed is the issue to do with properties charged to financial institutions. where some owners have cleared payments. So how does the Act deal with that? So if the property is charged, here I assumed you mean that the title to the land is charged. So the application for conversion will be made by the respective applicant, say in this case, the developer, since the developer is the charger. So once the application is prepared, it will be submitted to the Ministry of Lands by the bank or the bank's representative. The new titles will be issued. Once those new titles for each unit are issued, they will include an encumbrance showing that the unit is charged to the bank. Now, as the specific unit owner who has fully paid up, so the developer has these records and the bank should also have these records. The bank will then proceed to discharge that unit and just hand over a clean title. Henry, I think the rest of the questions have been answered. Yes.
Yes, thank you. Thank you very much, Sylvia, for the response. There's Wanjiku Kamau. Your hand is raised. Wanjiku Kamau, you have a question? Please unmute your mic.
Hi, everyone.
Hi, proceed. Wajiko, can you speak? Okay, I think you need to switch off for one gadget in there where you are. It seems to be having two gadgets on at the same time. So as you do that, I would like to inform participants that we have a poll question that has been posted. So if you can respond to it in the next 4 or so minutes, I think that will be useful. So just check and then you'll be able to respond to the poll question. As we wait for Wanjiku to sort out her gadget, there's one question that perhaps it might have been touched but not did come out very clearly, and I want to put it forward particularly for Waziri. And the question was asking, how will the existing long-term lease agreements between developers and apartment owners or buyers be handled, given that the long-term leases are legal contracts between parties that existed before the current law came into existence? And then the other one, perhaps to be able to take the two, is that does the Sectional Property Act also apply to townhouses scenario, that is horizontal sectional properties as opposed to only flats? Maybe Waziri, if you can just give more insight on that, we'll appreciate.
Henry, I don't know if I got you properly, but I think you are talking, the person is asking whether long-term leases will be converted. I'm not sure what the question was, but if that is the question, then yes, it is. I think the law requires that we migrate fully to the Sectional Properties Act of 2020. And that is the time I was saying we were given 2 years from December of 2020 when the law came into. And we've already done 8 months, but we spent that time doing regulations. So if the question is whether we are required to convert long-term leases to the ambit of the Sectional Properties Act, the answer is yes, we will be required to convert, because the only law that will document rights to sectional units is the Sectional Properties Act of 2020. We shall therefore be required to migrate fully to that act. In terms of other sectional units is not just apartments, it can be maisonets, villas, and all those units that share space. Those two will be registered under the Sectional Properties Act of 2020. I hope that is what the questioner was asking. Thank you.
Thank you very much, Waziri. I think they are talking about the agreement between the developer and apartment owners that are long-term in nature. And given that these are long-term contract, if the contract between the parties that existed before the current law came into existence will be affected. I don't know if that, Cyrus Kitwai, I think you're online, you can clarify if that is what you asked. Okay, I think, Cyrus? Okay, Sarah, proceed. I've unmuted you.
Henry?
Yes, yes.
I'm stepping aside to answer a call, so my colleague Tom is here. He can take the question, but I'll be back in like 5 minutes. Tom, are you online?
It's Waziri.
Yeah, so you can take the question. Let me take a call and then I'll come back online.
Okay.
Henry.
Yes.
I've understood the question. The long-term leases is an agreement between the developer and the lessees, those who have taken the subleases or the long-term leases, as one may call them. Yes, we are aware of this, and what we have done or have recognized is that the same long-term leases have provided for the interest, that is the reversionary interest, which is reserved for the owner. That is the terminal part of the unexpired term of the lease. You probably have it 30 days or even sometimes 10 days. That is reserved for the owner simply because it is the owner as the lessor who can then renew or extend when the lease expires, and deliberately provided in the lease agreements so that to safeguard that interest, and often for the benefit of the bearer of those long-term leases. And what we've done in the proposed regulations, we have segmented various scenarios, that being one of them, that yes, this is an interest that is safeguarded for the benefit of those who have those long-term leases, because they cannot, everyone cannot individually go to renew or extend such leases upon expiry. And so we have said that where the units have been, all of them have been sold, the developer has sold, and he has no issue with the reversionary interest, so much so that it's provided in the lease agreements on how it should pass from the developer to the management company. Management company, because we recognize that they hold this reversionary interest when it's passed to it in the trust of the owners. So when we have this understanding and knowing that the owners are the one that constitute the management company or incorporate it, or they're the ones who gain membership into it, so then it's very easy for them to decide on how to go about. So we have provided for this scenario that they can convert without any much issues, whereby it has not transferred that reversionary interest. It has all the units have sold, and the same has not transferred for one reason or another. There's nothing to stop it from transferring to the management company to hold it in trust of the owners. Then in this scenario, we are saying, yes, they can also convert without any issue. And where we have partly sold units, but again, the agreements, the long-term lease agreements provide that in due course or at a given time, the reversionary interest shall pass to the management company, again, to hold it in trust of the unit owners. Then, again, there we can have them convert because there is no issue there. There is no contestation there. All of them are in agreement. So if they can wish to go to sectional, but in cases where the agreements are express that reversionary will not pass to the individual owners for one reason or another, where you have such big developments, it may be impractical to have reversionary passing to the individual unit owners. Then in such scenarios, one will not be compelled to convert. I hope I've answered that question. Those are the proposals we've made in the proposed regulations.
I think we've been able to respond to it.
Okay, I'm back now, but I think I found Tom responding. Have you responded, Tom?
Yes, Waziri.
Okay, all right. Thank you.
Yes, Thomas responded to the question.
Thank you.
Okay, so let me just take one more question here. I can see there's a hand up. Wanjiku Kamau. Wanjiku, you can unmute your mic. Okay, Charles Gatecha. Unmute your mic and ask your question. And Ojiambo, is somebody Ojiambo also want to ask your question?
Yes, can I ask now?
Yes, introduce yourself and then ask your question.
Yes, my name is Ojambo, as you have stated. I have two questions. One is just on the last point, the speaker has talked about management companies, and I think there's this confusion about a management company and the corporation that the Act is talking about. The corporation has been there in the previous Act. The previous Act, there was also the requirement for establishment of that corporation. But generally what we see on the ground are management companies, which are registered under the Companies Act. So we just wanted to understand the difference between this corporation that the Act is talking about and what we generally see on the ground, which we are calling management companies. The estates which actually just only have management companies and not this corporation. So I want to understand the difference and how this corporation is going to be affected when it has been there even in the previous Act, but probably it was not affected. That's one. The second question is, there is also the issue of which units will fall under sectional properties, or which developments will fall under sectional properties. We have also seen a situation where we call them, I think, gated communities, where the developer only has a parcel of land which they have divided into portions. They have only divided the land into portions, but then they invite people to buy those portions of land, and the individual buyers construct units of those portions of land. Then they set up a management company to manage maybe the roads or common areas. But the houses have been put up by the individual owners. So the only thing the original, the title owner sold were pieces of land or portions of the land, but not the buildings thereon. We have such kind of estates now commonly known as gated communities, where people have constructed by themselves inside there. They bought portions of land and constructed, but they have common issues which they have then put to management companies. And again, we have estates like Green Park and many other assets which you have in mind. So whether all this will also be put under sectional property, but because we are not seeing a sectional plan as far as these gated communities are concerned. For flats, yes. For other townhouses, yes, which have sectional plans, yes. But how about these other so-called gated communities where people have put up their own houses inside there? Thank you.
Thank you very much for that question, Mano Jambo. We'll get a response. Maybe before we do that, can we hear from Paul Tairu? Paul Tairu, can unmute your mic?
Good afternoon.
Yes, afternoon.
Yes, my question is exactly what the previous question has asked. I've actually posted it on the Q&A. So if Waziri has access to that, she could. It is not exactly sectional property, but it's kind of related. I can read it out. It says, even though we are discussing the Sectional Properties Act 2020, can CS Farida Karone please tell us how the government can help investors in cases where developers of gated communities fail to give us registered subleases and share certificates in the estate management company, or to build the infrastructure, paved roads, electricity, and so on. Yet they're asking for payment. We need help from the government for such cases. Thank you.
Thank you very much. Thank you very much for that. In the meantime, you can respond to the poll question that we posted. It's almost running out, so I can give you a response. And let's take the last question from Brian and Patrick Wadara, then we close. You can get a response and then we close the session. So Brian, can you unmute your mic and ask your question, please? Brian M. Brian, proceed. If you can't get Brian, then let's get Patrick Wandare.
Can you hear me?
Yes, we can. Proceed.
Good evening, Madam Minister. My name is Patrick Wandare. Sorry, I have a problem with my throat, but all the same, I'll try to speak. The question is this, and this is specifically for members of cooperative societies. You find that in a cooperative society, their arrangements normally are that you buy a land, a shield of land, and then it is divided into pieces so that members for those members can be able to buy them. Now, when you buy land, you know you're buying your personal land, something that you will use during the end of the day. But then for the purposes of convenience, you find that the management team, they go in and change land from agriculture to what is other terminologies that I cannot even remember. So much so that your land is not your own land. It's a leased land. And yet you bought it at whatever price, you bought it knowing that you're buying your land for your children as they come, as you fade off. And this is a problem that has been there and is remaining there. So most of us are suffering in silence, unless otherwise, either now or tomorrow, Madam Minister, you can think about it. And even if you don't give me the answer now, I can be able to wait. And I thank you.
Thank you very much, Patrick, for that question. I'm sure Waziri has heard you and she'll be able to give a response. I want us to now get back to Waziri. I think the questions are mainly for Waziri, so that she can give us a response and then we move to the next item. Waziri, please.
Henry?
Yes.
Waziri had to step aside a little bit.
Okay.
Because there's an emergency that has happened. One of our staff has been killed.
Oh,
and so she has stepped aside to handle the issue with the human resource. I think some ID along the Somali border, something that has happened, some accident. So she told me to proceed with the answers. If I may, very quickly, about the units that people have developed themselves in gated communities. I want to say that sectional is about the units, the buildings that have already been developed. And so the surveyor comes into place to take the measurements by, preparing the survey plan. which is a sectional plan, in respect of an existing building. So the act comes into place post the event, after the building has been done. The act does not apply in scenarios where people have not built, or they are going to build, or they have been sold their land to develop. That is not how the act operates, unless in circumstances where people may want to now convert an already existing, estate which has already been built, and probably they may want to convert it from the long-term leases, or rather take it to the sectional way. Then that is probably when the act can come into place to apply. The corporation vis-a-vis the management company, the 1987 Act, though provided for the corporation, it didn't really provide on how that corporation was supposed to be incorporated. So there was confusion. Yes, it has made mention of the corporation as an entity that will manage the units, but how was it supposed to be incorporated? Under which regime? So that's why there was that confusion. That gap was exploited by having the management companies that are registered under the Companies Act being registered to manage the units and the owners, and which is one of the reasons it is under this premise that the Sectional Properties Act, the current one, 2020, was enacted, so that to bridge some of these gaps. And in the present act, it is very clear under which regime the corporation is supposed to be registered. It is very clear what happens after registration, a certificate of registration is issued, and all that. Things have been made clear. And going forward, I don't think there is going to be any confusion between the management company and the corporation, because it is the corporation that is going to manage. And in the proposed regulations, we have also developed generic bylaws under which, when the management, the corporation gets registered, or rather when one presents a sectional plan for registration, it automatically gives rise to registration of the corporation. You have to present, there's a special form that you present for registration of the corporation, and alongside with that form, you do the bylaws. So I don't think there is going to be any confusion. The latest the latest question, though I didn't get it very well, I'm not sure whether it was alluding to change of user when you make an application for development, when you seek for approval. Because that is the time when Waziri was speaking to me of her exiting from the meeting. Probably if you got it well, Henry, so I can answer that question.
Maybe we can repeat myself, sir, with your permission.
Quickly. Yeah, very quickly, please.
The issue is you members of a cooperative society team up and they are able to buy land.
Yes.
That land is supposed eventually to be subdivided into pieces so that each member can be able to get the land, of course, normally through the balloting. And when you have already gotten your portion, but then you know very well that you have, this is a very typical case. So please don't look at it digitally, just look at it typically. And then later on, for the purposes of convenience of management team, you find that it is changed into a convenient section of the law that from agricultural to, I don't know, those terminologies that you are bringing in, and then it turns out that now you are not actually the owner of the land. You have a leased land. That land is leased to you. You see, that's taking
I've
away
gotten your
land.
point.
If you
If
have,
you
then
may,
I thank you very much, sir. Thank
if
you.
you
God
may,
bless.
If you may, I've gotten your point. I think the problem is raising is what used to obtain when approvals are sought, especially at the county level, the local authorities, when approvals were being sought for subdivision, when such approvals were sought, it was the local authorities automatically, if the land was agricultural, or rather, if the land was freehold, they could change, the use of that land from agricultural to commercial, just because of the density, because of many, it kind of now becomes a settlement area. But you see now, under the Land Act, this was Parliament handled this issue by saying that you cannot change the tenure of land just because one is giving, seeking an approval for development. So for that reason, I think that is an issue that has been sorted out by statute. No one is allowed to change the tenure of land, whether from agricultural or rather freehold to leasehold. It is not allowed now because the law protects you. So you need to know that the law has protected you when it comes to that. But issues that happened in the past, we may probably be not able to provide solutions in respect of the same. Yes, Henry?
Okay, thank you very much, Tom, for those responses. I note that there are still a number of questions maybe on the chat box, but also we cognizant of the fact that time has really gone. So what we are going to do is that the questions that have not been exhaustively responded to, we'll share that. Maybe you can give a response to us in written form, and then we can share with our members through our channels of communication. So for now, ladies and gentlemen, I want us to bring a close to this session. And I would want to request maybe Sylvia, if you have some closing remarks just for 1 minute, you can make closing remarks before you go to Waziri. Sylvia, are you there?
So I think, like you've said, the questions are quite a number. So perhaps my suggestion would be if they can be summarized and then sent to us, then we can be able to share the answers with you for circulation. I've tried to respond to quite a number of them, but there's still a bit that I haven't covered. Aside from that, Henry, thank you once again for the opportunity, and I look forward to more interactions with Kara. Thank you.
Thank you, Sylvia. Share the questions with you. So, Waziri, Paul, we understand that you have an emergency, and of course, Tom has been able to step in very well. But as you make a closing remark, I think there was a question about how and who do we contact at the ministry to assist us on the process of conversion and the whole issue about the Sectional Property Act. Maybe as you make a closing remark, you can direct us on how best you can be able to engage with your ministry on this particular subject.
Okay, thank you, Henry. I'm sorry I missed the last 15 minutes because we have an emergency here in the ministry. But my apologies. I hope Tom was able to step in and fill the gaps though. So in terms of customer care, Henry, we have on the Artist as a platform, we have a live customer care service. Anybody who has a concern or an issue can either chat up the customer care desk or drop in their contacts and somebody will get in touch with them. We have a fully fledged customer care service. And then in terms of the questions, there are many of them, the 32 that you sent, we will respond to them and then send them back to you. And you can circulate the answers if there are any that we missed out. But suffice it to say that we would really want to work with all of you, to engage all of you so that we fast track the implementation of this law. Personally, I believe it's a good piece of legislation. It has challenges, it has some gaps, but I think we can work with stakeholders in order to fill the gaps that exist in the law. But let us not focus too much on the gaps because there are not many, there are few. Let us focus on the full implementation of the law because it will accrue some benefits to home and property owners. I thank you very much for the opportunity to engage, and I'm always happy to engage with you and engage with our stakeholders on these matters. Thank you very much. Good afternoon.
Thank you very much, Waziri. You've talked about live customer care service. Is this on the website, or is there some number that we can call?
If you go to www.artisasa.go.ke, there's on the landing page, there will be a customer care portal, which you can, it's a chat box on the customer care service.
Okay,
if
that's
you
well
send in
noted.
there your contact, somebody can get in touch.
Okay, thank you very much.
Thank you.
So, ladies and gentlemen, we've come to the end of this session. We had said that we'll be done by 4:30. I can see we are slightly late, but I believe it's because the issues were very interesting and very informative. So we want to thank you very much for creating time to be part of this discussion, which could not have been possible without you. Of course, we thank our partners also for being part of this support. And Sylvia and Waziri, want to thank you very much for sharing with us very, very useful information. And I'm sure that each one of us is now better informed about the law and many other aspects that comes with it. So as Kara, we are happy that we are able to have this interaction. And as been mentioned, we'll be able to share the questions that we have, both the ones that are sent in advance and the ones that have been sent on the chat box. We'll share with our speakers. Then once we get the response, we should be able to share that with you through our various communication channels. So that will be done in due course. Otherwise, we want to say that we are really looking forward to engaging with the ministry on not just on this particular law, but on many other aspects. I remember early in the year, we also had a very, very useful discussion on the digital process going on at the ministry, and we were able to learn a lot. So we'll continue this engagement and continue contacting the ministry and just providing a platform for people to be informed and to be able to make informed decisions and choices. So thank you very much, ladies and gentlemen. If there's no any other issue, I want to say that the session has come to an end. If you've not responded to our polling question, please do so before you log out, and be on the lookout for our next communication on when we are going to have our next forum and on which topic. So asanteni sana, and have yourself a very, very nice evening. Thank you.
Thank you. Good afternoon.
Asante sana, Henry and Kara team.
Thank you very much to Kara.